Okay, welcome to the ACI-LAC webinar on legal considerations for airports construction projects. In today's webinar, we have the pleasure to count with our speaker, David Pratt, President at PRT Group. But before we start, we would like to share with you that as usual, we have simultaneous interpretation. You could select Spanish or English in the Zoom menu. Besides, if you want to hear the original audio, please click on, if you don't want to hear the original audio, please click on mute original audio. As you can recall from other webinars, the chat function is disabled, and in case you want to ask any questions to the speaker, you will have to send it to the email address that you find on the screen, info@aci-lac.com.io. Sorry. The Q&A session will take place at the end of the presentation. I would like now to give the floor to David Pratt, President at PRT Group.
Thank you, Carla. Good morning, everybody. Greetings from Toronto, Canada, where the temperature is a balmy 2 degrees Celsius. So I'm sure it's much warmer for most of you this morning. But it's my great pleasure to be here to talk about this interesting topic. And I look forward to sharing my thoughts and also answering any questions at the end if they come up. So next slide, Carla. So the agenda this morning is to talk about legal considerations for airport construction projects. We'll start with a brief introduction, an overview, and then we'll look at the different parts of the project cycle, project planning, tendering and award, construction and post-construction, and close out hopefully with a nice discussion at the end. Next slide. So a little bit about myself. As Carla said, I'm the president of PRT Group. PRT Group is a technical and transaction advisory firm providing services in the international aviation sector. We're currently active in the LAC region, in Montego Bay on the runway extension project, advising GAP on their other concession in Jamaica. And most recently, we've been engaged by the Bermuda Airport Authority to help with a renewable energy project at their international airport in Bermuda. I've had the pleasure of being involved in projects in a lot of places in my home Canada, a bit of work in the USA and Europe, but really our focus has been LAC. So it really is a pleasure to be addressing this particular group this morning. I feel like it's the home team, as it were. So next slide, Carla. So airport construction projects and really all construction projects have a life cycle. You know, it all starts in the beginning with project planning, you know, putting together designs and specifications, and really a key part in the early days is understanding the risks with any undertaking. And then once the planning is complete and the designs are done, then we move into the tendering and award phase, which has the important legal documents of the tender and contracts. And then from beyond that is the implementation phase or construction, which is when things usually get really interesting. And then, of course, at the end of construction, there's the post-construction period. So the responsibilities don't end when construction is complete. There's still a period of time that we need to pay attention to. And then at the end of that, the project closeout and handover or hand back to the owner. So we'll be looking at all these stages and the fact that legal considerations come into play at all stages the project lifecycle. It's not a one and done. It's an ongoing relationship. Next slide, please. So in the first phase then, project planning. As I mentioned, a big part of the legal considerations are around the risks associated with these projects, and airports in particular have, increased risk profile. It's not like a typical road construction or other civil type work. There's a lot of moving parts, as we all know, at airports. So the risks are many and varied. And I've tried to list some of the key ones here that we need to consider with our legal advisors. Initially, just defining the project scope is key, and do you do the project all as one big undertaking, or do you break it up into a program? And that's really key, because as we move into the project, we want to be able to define the scope as best we can up front to avoid what we like to call scope creep, where the project gets bigger and bigger and more expensive and takes longer. So it really is key to pay a lot of attention to the scope and project definition early on. The graphic here is from the Montego Bay project, the runway extension, and you can see, although it's called a runway extension project, it does have many various components that need to be considered. And when we looked at this a few years ago, it was a big effort to really piece together all the various components in a logical manner that made sense from a delivery and a legal perspective. Some of the issues that we need to look at as well as part of that is the utilities. That's things like power, telecoms, etc. And the big risk there is usually the utilities are controlled by a third party. So that makes the risk difficult to manage. If you're under control, you can manage a risk, but utility companies tend to march to their own drumbeat. So having agreements in place with utility companies is key, and that's where the legal advisors are extremely helpful in getting those agreements in place to protect the owner. Geotechnical is another area that's often a big risk item. Contractors and engineers often say that the biggest risks are when you're in the ground. Once you get out of the ground, then the risks tend to disappear, because then the unknowns are known, and you're able to move on. Unforeseen conditions are a regular culprit for project delays and extra costs. And we did run into this as well on the Montego Bay project, despite having done extensive geotechnical investigations. Until you get out there, you don't really find things like high water tables or unexpected rock or soft ground and these kind of things. So we need good legal advice to make sure these items are covered. Another key item is permits, licenses, and approvals. And this can be quite a long list. It ranges from everybody from the regulator, the civil aviation authorities, to environmental agencies, to external ministries who may govern things like approach roads and things like that. So careful consideration needs to be put into how these permits, licenses, and approvals are managed. And again, a big part of that is coming to legal agreements with the various parties that control these permits, licenses, and approvals. Program or schedule, as some people call it, is another key risk that needs to be considered. Again, when we're planning the project, we need to be realistic in how long we think it will take. There's often what we would call an optimism bias, where people think, oh yeah, everything will go good and we'll be done in a year. But we really need to look at that with clear eyes and a clear mind, and be realistic, so that we're not setting ourselves up for problems later. And how the legal people can help us deal with that, I'll get into that a bit later. Property is often an issue, particularly when we're looking at expanding the airport facility as part of the project. And again, we did run into this at Montego Bay, where additional property was required, and the legal team was heavily involved in all aspects of that, as you can imagine. And it also isn't just necessarily property itself. And sometimes the issue is there are people on property that you may own, but they shouldn't be there, squatters and the like. So again, we need good advice and support from the legal team in dealing with property acquisitions, easements, and illegal settlers. On the design item, that's a key risk as well, and it's something that can directly affect the owner, or if there's an opportunity to transfer that risk, that's something that can be considered at the planning stage as well. In terms of operations, as you're all involved in the airport field, airports are a living organism, right? There's lots going on all the time, and to do a construction project in the middle of that can be quite a challenge, as you can imagine. Again, Montego Bay, the challenge there is there's only one runway. So when you're trying to extend that runway while it's in operation, as you can imagine, is quite challenging and takes a lot of coordination, and working with the legal department, making sure appropriate protections are in place so that operations aren't impacted. And then the last one on the list, and there are others, but these are the ones that certainly tend to come up on a regular basis, is the environmental matters associated with the project. And that includes, the whole range of environmental issues, things like contaminated soils that may be out there, environmental permits, going back up to the permits, licenses, and approvals. If any environmental permits are needed, those need to be managed carefully. And then as well, the behavior of the contractor on the site during construction, so that no environmental issues are come up, for example, spills and things like that. So quite a long list of risks that need to be considered, all requiring legal advice and considerations. And coming out of that is really, aside from the scope and definition, is the delivery model. A lot of airports are done through the traditional design bid build model, usually because airports like to have a lot of control over the design and the bidding and the construction, mainly because they are very complicated and there's a lot going on. But sometimes there are opportunities to look at transfer. The thing with that model is the owner does retain most of the risks, right? They retain the design risk, they retain a lot of the approval risks, program risk, etc. So while you do maintain control, you do retain a lot of risk. If there's an opportunity to transfer some of the design risk, then the design build model can be considered, and actually we did do that at Montego Bay on one of the elements, the nav aids, because again, in managing risk, the credo is really, the risk should be managed by the party that is in the best place to manage that risk. And in the case of the nav aids, it's really an all-encompassing approach. So to have that company design and build the infrastructure, it made a lot of sense. So we transferred that design risk to the contractor and are moving forward on that basis. Other opportunities to transfer risk is the design build finance model, where if program is really important and the end date is really firm and needed, that some owners will use the design build finance model, where the contractor is only paid upon completion of the project or on specific milestones, to really incentivize adherence to schedule. If he doesn't get paid until he's done, then he's certainly incentivized to get the work done on time. The other two, 4 and 5, the design build finance maintain and the design build finance operate maintain, are really where the owner is looking to transfer significant risk over to the contractor, and that's usually taken on projects that are very complex, very long term, and really, we're moving to more of a concession arrangement here. So we won't get into that too much here. That's a topic of its own. But these are the kind of decisions that need to be made early on, and and do require a lot of support and input from the legal team. So, okay, so that's project planning. Carla, can we go to the next slide, please? So we've gone through the planning. We've figured out the scope. We've defined it. We've identified the risks. We've if we've done design, if we're doing the traditional model. So the considerations now in the tendering and award phase are, okay, what's the form of contract? And is it a FIDIC, which is quite common in LAC. I've seen FIDIC used probably in most of my experiences in LAC region. It's a good model. It's fair to both sides, but it doesn't always suit the purpose. So sometimes a bespoke model is needed, a tailored solution for a specific project, and clearly this is where we need good advice from the legal team as to what are the advantages and disadvantages of one or the other. So that's the key consideration. The tender process as well is key from a legal point of view. If the process isn't done right, it does open it up to challenges, and those really need to be avoided at all costs. It's best to have a process that starts and finishes with an outcome that everybody accepts, even if they're not successful. And to really achieve that, a couple items are important. Fairness. The process needs to be seen as fair and open, that there's no favoritism, that it's and it's also a transparent process, so there's no decisions being made or taken or that could cloud the outcome. So again, this is where the legal input, legal aspect is very important, to make sure that the process is fair, transparent, and defendable, and avoid any appeals or issues like that. Other things to consider with the tender process is the bid security, to protect the owner. If a bidder comes in and he's low bid and he looks good, but then he realizes he maybe left $1 million on the table and wants to back out, the bid security is there to protect the owners, such that if he were to do that, he would have to default on the bid security. So it really keeps the contractors on their toes to submit a good bid, and stick to it when it's submitted. Further area where important legal consideration is the performance bond that would go along with the project. The performance bond is there that if the contractor fails to perform, that there's adequate funds held in security to protect the owner to complete the work, whether that's bringing in another contractor or retendering the project or whatever, that there's sufficient funds available for that. And this is a key item because we need legal support in drafting the form of the performance bond, and also reviewing the bonds that do come forward. Despite our best efforts, sometimes people put forward bonds that aren't necessarily callable or difficult to call, and we need good legal advice to make sure that those bonds are good. The other element that's important to protect the owner and to be considered at this point is the liquidated damages. What that is if the contractor is late in delivering the project, either in terms of completion, the end date, if they're not done by when they said they would or when was expected, then penalties would be applied by the owner. And in the case of airports, the other one, the interim milestones or stages are probably as important, and in some cases even more important than the final completion. For example, as I mentioned at Montego Bay, where we're working on the one and only runway, they do work at night, and that runway has to open in the morning, right? So if it doesn't, then there's severe penalties that would apply. So it really motivates the contractor to not fool around and make sure that he meets those interim milestones and even the completion date, because these damages can be quite substantial. Now, where we need good advice here from the legal team is on the amount of those damages. Legal precedents have been that you can't just pick a number, call it $1 million a day or something, because it needs to be defendable. So, we need good advice from the legal team as to, when the project managers and the engineers are determining what those liquidated damages should be. The legal team needs to opine on their defendability and suitability. So a key input here and key consideration. The next item is variations and claims. Now, we don't get into those in the tendering stage, but we really need to anticipate the fact that there will be likely variations and claims on the project, and to have a clear process in place to be able to deal with those in an effective manner. Also, a couple other key considerations are the owner's role. Some owners like to be very hands-on, very involved in the day-to-day aspects of the project, and some owners prefer to take a more backseat or silent role and only get involved when needed. So that needs to be clear up front, and good advice from the legal team is helpful there. And then same with the owner's representative, the engineer, the project manager, any others who are authorized to represent the owner. Their duties and responsibilities need to be clearly defined, and legal advice on how to structure that and present that in various contracts with those players is very important. The graphic here was, again, I go back to Montego Bay because it's my most current one, but this just shows what happens once the preferred proponent has been identified. a clear process is laid out, that they would be sent a letter and the agreements would be put in place, the proper notices would be sent, and then the project would commence. So, okay, next slide, Carla. Construction. Okay, well, this is where I guess the rubber hits the road, as it were, and key considerations during construction. Obviously, number one is everybody's mind, particularly the contractor, but the owner too, is payments. And it's important to have a good payment process that's clear and defined, and within certain timelines. And so, the contractor has certain responsibilities with respect to payments, but the owner does as well. And so this is important, that the owner needs to appreciate that they have to process the payment in an efficient manner as well. Otherwise, they could be open to claims. So, we work closely with the legal department to make sure the payment structure, the payment process is clear, and any deviation is managed. Variations in claims, we talked about that a bit earlier in the previous slide, but during construction is when these really come into play, right? I don't think I've been on one construction project in my entire career that hasn't had variations in claims. So, and again, this is important from a legal point of view, that some of the challenges that come in are legal in nature, where terms of the contract are challenged, or conditions of the contract are challenged. So I'd say in most variations and claims, legal input is paramount. And same with delays. It's a similar vein. Delays can be caused by a lot of things, and usually when they happen, people start pointing fingers at each other and saying it's your fault. No, it's your fault. So it's really good to have the legal support in assessing these delays, if they're owner driven, or if they're contractor driven, or driven by an external force. Managing and dealing with those are key. One of the more difficult considerations is termination. We don't like to think about that, but it is something that happens sometimes, due to contractor non-performance, or even other means. It could be an owner side issue that they need to terminate for whatever reason. So obviously that's a very sensitive matter, that the legal considerations and how termination is dealt with is quite important. So we need to have clear understanding of how that could work, even though we all like to be, as I said earlier, optimistic and think it'll never happen. It can happen and does happen, and we do need to be ready for that. And again, during construction, just like during the tendering process, the owner's role needs to be clearly defined, as well as the owner's representative role, so that there's no mixed signals being given to the contractor, that when instructions are sent, they're coming from the right party and with the right authority. The graphic here shows a typical payment process. It's not too complicated on the surface. Typically, the contractor applies for payment. The engineer or the owner's representative will prepare a payment certificate, and then the owner will make the payment to the contractor. So one thing we've done at Montego Bay to help that process move more smoothly is we introduced the last three boxes are pretty well right out of FIDIC, but the first box is something we've introduced at Montego Bay to try and keep the process moving smoothly, is that prior to a formal application for payment, the contractor meets with the engineer's representative and does a pre-application review so that they can hash out any differences. And then when the formal application comes in, it then has a better likelihood of meeting the timelines. Because these timelines, if not met, if the owner is slow and doesn't meet these timelines, then, excuse me, the contractor is entitled to relief. So again, important to pay attention to the timelines and process. Okay. So if we could then move on to the next slide. So I mentioned the claims process. So this graphic represents the flow process for a claim. That if the contractor feels he's entitled to something, call it a potential claimable event, then they would submit a notice of that claim. And then the engineer's representative would look at that and decide if it's valid or not. So this is usually where the legal team would get involved in this process during construction. That if the engineer needs to consult with the legal team on his initial response, this is the place to do it. And if it's determined to be a valid claim, the engineer's representative will go through that, and an agreement or determination will be made. And again, this is where legal input is key. If we're going to be issuing a change order or entering into some other agreement, the legal team needs to be part of that without a doubt. Okay. Next slide. Okay, so we've gotten through construction, hopefully with not too many claims and on time and all of that. But again, we're not done, right? No job is over until it's all over. So important things to consider here are the construction records. The contractor will need to produce records, maintenance manuals, etc. So that's important. There's a warranty also that would need to apply, and this is a key item for legal, is making sure that warranty is sound, the requirements are clear, so that there's no misunderstanding, in order that the contractor is on the hook for the next item, any defects, the defects liability. So those all need to be considered at this time, and then once all those things are in place and the defects liability period is ended, then there would be a handover of the completed project to the owner. And hopefully it all ends with a firm handshake and everybody remains friends, but it doesn't always go that way, and that's why we need good legal advice through this period as well. Okay, so next slide. So we'll just kind of, I guess, wrap it up here in that, we've been talking about legal considerations, but I think you've been hearing throughout the presentation that it's really more than one party. There's a team that's required to address all these issues. The legal part of it is very important, but it also is a balance of legal inputs, the technical components, the engineers, the designers, a lot of what they do is dependent on good legal advice and legal support and legal documentation, and same with the finance side of it. Just making sure there's adequate funding, if it's a traditional type project, or if it's more of a design build finance or alternative type delivery, then obviously those linkages are key. And then at the top of all this is the owner of the airport, that needs to pull all this together. So it really does take a team, and none of us stand alone. We all need to depend on each other for successful delivery of airport construction projects. So that's the presentation. Thank you very much for your time, and I'm happy to open it up now for any questions from the audience.
Thank you, David. Just a quick reminder. Please send your questions to info@aci-lac.iro. So we are going to start with the Q&A. I have some questions here. So the first one is, how best to engage legal advisors in the project cycle?
Yeah, that's a good question, Carla. And I guess my initial response would be early and often. I think you may have seen from the presentation that the legal advisors need to be there from the get-go. In the planning phase, is particularly important to engage the advisors to make sure all the protections are in place as we move forward, and to help assess all the risks, manage the risks. It's key that they're involved right away. But then as we move through the project, again, from the presentation, you could see that there's a role to play in all phases. The tendering is really important, making sure the contracts are right, the process is right, and then even into construction, when things come up, the legal advisors are key, particularly if there's delays, claims, and heaven forbid, termination. And then at the end, not so critical towards the end, but still it's important, especially if there's any disputes on, are they complete or not, or are defects complete or not, that the legal advisors can provide good advice then as well. So again, it's early and often.
Thank you, David. Next question is, at which stage of the project cycle are legal issues most likely to arise?
Yeah, again, a good question. And really, in the planning and tendering stage, the legal issues that come up are more anticipating what the risks and issues might be. But when they really manifest themselves, it tends to be during construction, right? That's when the rubber hits the road, as it were. The contractor's engaged, real money is involved, and that's where the actual issues are most likely to manifest themselves. Sometimes in tendering, if there's challenges or problems with the tendering process, that the legal team or legal issues may arise, but it tends to be during construction that we see if the issues are going to come to the fore. That's when they do come.
Thank you. Next question says, despite addressing all the legal considerations, many airport construction projects still tend to be delayed and go over budget. Why is that the case?
Yeah, well, that's yeah. Unfortunately, that's a sad reality that the projects do, especially the traditional design bid build. They tend to, um, uh, unfortunately, history has shown that they tend to take a little longer, or sometimes a lot longer, and end up costing more than originally expected. But I don't think it's necessarily just a legal matter. As the last slide showed, it's a number of players that are involved, and so often, why projects are go longer. Well, it could be a number of things. Anything from, big issue is unforeseen conditions. So whether it be geotechnical or weather, or, as we all experienced, a pandemic or epidemic, wars. So things that are really beyond the control of people. But the key thing, though, from the legal point of view here, is that, yeah, these things happen. Projects are delayed. Projects run over budget. But I think the key role for the legal advisors is to help us make sure that, okay, these things are going to happen. How do we best protect the owner, right? And that's, I think, the key point here is, yeah, this stuff is likely going to happen. So we really need to make sure that the protections are in place. Things like liquidated damages, termination clauses, and things like that will protect the owner when, I won't say if, when these things happen. Okay.
Okay, thank you. Thank you, David. I have another question here. And it said, it is important to include a dispute board body during the construction stage.
I'm sorry, could you repeat the question? Is it important? Was that the question?
It, yeah, it
Yeah.
said important to include a dispute board body during the construction stage.
That's a good question. There's a bit of a, I guess, mixed view on that. Some people think that it's a good idea to have a dispute body in place from the beginning, and that is something that FIDIC usually suggests that is included. And there are advantages to having that in place, that, if and when disputes arise, then the people who are asked to opine are familiar with the project, and there's not a lot of time required for them to ramp up and deal with the issue. However, the other side of it is that can be a very expensive proposition. So, but and so some owners shy away from it and prefer to just deal with it as things come up, and bring in dispute, technical experts or whatever as needed. So personally, I think it's a good idea to have some kind of board in place, whether it be a full dispute resolution board as per FIDIC, or even technical experts identified up front, so that when disputes do arise that aren't able to be resolved at the project level, that people can get involved quickly. But a full dispute resolution board, I'm not convinced that that's the best way to go. It does introduce a lot of extra costs that not necessarily the best bang for your buck, I would suggest.
Well, we don't have more questions. So thank you, David, for sharing this information with us today. And thank you all for your participation in the webinar. If you have any more questions, please send it to us to the email in the screen, info@aci-lac.io, and we will follow up on it. So thank you very much again and have a great day.
Thank you, Carla. Thank you, everyone. Take care. Have a great day.